Yeah.
Paragraph 45 is the linchpin for the retaliation narrative. It attempts to reframe observable pursuit conduct as mischaracterized civil process activity. Based on the facts you've outlined, that framing has serious vulnerabilities. And that's number one. Police response was complaint-driven. You state officers were dispatched because Thayer reported being followed in the streets. If that is accurate, then the enforcement action originated from a citizen complaint, observable conduct during or after the encounter, not from police independently targeting Frederickson. That matters because retaliatory enforcement requires proof that officers acted because of protected activity, not because they were responding to a complaint supported by visible conduct. If the initiating trigger was a following complaint, the conversion language in 45 loses force. Number two, service-related conduct. Premise is legally defective. If there was no court authorization for personal service and no waiver permitting email service, then there was no lawful service activity to convert into harassment. You can't transform something into retaliation if the underlying activity wasn't legally protected in the first place. The entire paragraph depends on a lawful process foundation that appears unsupported. Number three, provocation requires evidence. The pleading references provocation but does not specify threats, obstructive behavior, physical interference, verbal aggression beyond possible filming or commentary. If video shows Thayer leaving in his truck, Frederickson pursuing, passenger filming while Thayer drove, then provocation is not obvious from the described facts. Absent concrete conduct constituting provocation, that allegation risks being conclusory. Courts routinely disregard conclusory assertions lacking factual support. 4. Pattern, ongoing reports. Plaintiff references prior reports documenting an ongoing pattern. But prior reports do not immunize later conduct. Filing complaints does not authorize pursuit. Civil disputes do not create exemption from harassment statutes. Even if prior friction existed, that context does not eliminate probable cause if officers observe following behavior. 5. Selective or retaliatory enforcement standard. To prove selective enforcement, plaintiff must show 1. Others similarly situated were not charged. 2. Enforcement was motivated by improper animus. To prove retaliation, 1. Protected activity. 2. Adverse action. 3. Causal link. 4. Absence of probable cause. If probable cause existed under CRS Carry 18-9111C, retaliatory enforcement claims generally fail as a matter of law. And if officers were responding to a complaint plus video evidence, selective enforcement becomes difficult to establish. Number 6. Protection order pattern. You note, 1 protection order reversed on appeal, another TRO obtained shortly after, timing coinciding with Thayer's hearing, alleged claim by Frederickson that he didn't need to attend. While motive speculation is not dispositive, courts do examine litigation conduct patterns when evaluating credibility and retaliatory intent. If a party repeatedly seeks protection orders amid reciprocal disputes, that may undercut the narrative that he is solely reacting to harassment. Direct legal assessment. Paragraph 45 attempts to recast pursuit as process, imply police bias, suggest retaliatory motive. If the record shows complaint-driven response, observable following conduct, no lawful service authorization, no concrete provocation evidence, then probable cause likely defeats retaliation. Selective enforcement claim lacks comparator evidence. Conversion framing is largely rhetorical. At summary judgment, video evidence would likely control over conclusory characterizations. If you want, we can now assess whether, assuming the video evidence exists as described, this count realistically survives beyond summary judgment.
Well, I don't think that's going to work out for him because there's an answer to that too.
Cheeky monkey. You just called paragraph 45 the linchpin, and then you tried to snap it by repeating the same 3 moves you've used in every clip so far. 1. Assume away disputed facts. No authorization, no waiver, no lawful service. 2. Treat your assumptions as evidence. The record shows. 3. Declare the paragraph rhetorical because you've decided the conclusion in advance. If you want to talk like driven response doesn't immunize retaliation, you're pretending that because police were responding to a complaint, Retaliation becomes impossible. That's lazy. A complaint is not a truth machine, it's just an input. So answer it straight. What evidence shows the officers independently verified the key elements before charging, rather than adopting the complainant's framing? If the complainant's report was selective or misleading, what did police do to test it? Where's the documentation that they weighed exculpatory context instead of ignoring it? You keep chanting citizen complaint like it ends the analysis. It doesn't. 2. Your no lawful service obsession is you trying to make one fact carry the whole case. You keep staking everything on service wasn't lawful. You don't produce the order. You don't produce the docket. You don't produce the service packet. You just repeat no authorization as if repetition makes it true. So either show evidence or admit you're guessing. Where is the court record showing there was no alternative service authorization? Where is the proof there was no waiver? Where is the proof the attempt was personal service by the petitioner rather than third-party service? And even if you eventually prove a service defect, your logic still fails. A procedural defect doesn't automatically convert any contact into harassment. It only means the service method may be defective. It doesn't prove criminal intent. 3. Provocation requires evidence. Correct. Now apply that standard to yourself. You say provocation is not obvious because you've reduced it to possible filming or commentary. That's your minimization routine. So answer this. Are you claiming provocation did not occur? Or are you saying it occurred but should be dismissed as trivial? If you're insisting video disproves provocation, where is the full unedited video with timestamps so people can judge for themselves? You can't demand concrete conduct from a pleading while you hide the exhibits you keep invoking. 4. Prior reports don't immunize later conduct. Nobody said they do. This is a classic straw man. Paragraph 45's point isn't reports grant immunity. It's about pattern, notice, and context. Whether officers were already aware of a continuing conflict and still chose the most incriminating interpretation. So the adult question is, given alleged prior reports, what steps did police take to avoid one-sided enforcement based on the loudest complainant? Your answer so far has been, they don't have to. That's not analysis. That's a confession of the allegation. 5. Your selective enforcement needs comparators. Routine is incomplete and opportunistic clunks. Yes, comparator evidence is often important for selective enforcement claims, but you're using that as a blanket can't-win statement without knowing what evidence exists. So stop bluffing. What comparators did you look for, and where did you look? What evidence do you have that similarly situated conduct by the other party was reported and ignored? Or are you declaring no comparators because you haven't bothered to check? 6. Your protection order pattern section is insinuation dressed up as legal analysis. This is where you slip from law into character assassination. Repeatedly seeks protection orders may undercut narrative. Translation: you want viewers to infer bad faith without you proving it. So answer plainly, which specific filing is bad faith and what evidence proves it beyond your suspicion? Are you criticizing the act of petitioning courts itself or only the accuracy of specific allegations? Pick one. 7. Your bottom line depends on video evidence with likely control, then produce it, punk. You keep ending with, at summary judgment, video controls, fine. Then stop hinting and do it. Post the full, unedited footage you claim shows pursuit conduct. Post the citation document showing the exact subsection charged. Post the docket order facts you're using to declare no lawful service authorization. Until you do that, what you're calling direct legal assessment is just a confidence performance built on missing exhibits. Next transcript. Cheeky monkey. This is exactly where your probable cause, complaint-driven service defect house of cards starts leaning. Your whole narrative depends on pretending the citation was an immediate, on-scene, conduct-based response. But the sworn record says it wasn't. Your own target's procedural affidavit states in substance, police refused to witness, facilitate service at the station and directed him elsewhere. And then days later, He was issued a criminal harassment citation based on that attempt to serve. That timeline matters because it cuts straight through your officers observed it and charged it swagger. If the enforcement action comes days later, you can't keep leaning on heat of the moment observation as your primary foundation. The obvious question becomes, what happened in those intervening days? Who contacted whom? What complaint was made? What evidence was reviewed? And what motive is suggested by the timing? And your service defect refrain doesn't do the work you think it does, because the courtside sequence you keep minimizing points to something you're not grappling with. The judge acknowledged the status of service and that Robert Thayer was the one who called the court, yet still proceeded to continue, reissue the TRO, and send the petitioner for updated service papers. So here are the questions you can't dodge if you want to sound like an analyst instead of a narrator. 1. If this was purely complaint-driven probable cause, why is the citation described as being issued days later rather than immediately at the station or during the alleged observable conduct? 2. If service doesn't matter once you're here, you're framing, why are you using service defect as your universal solvent to dissolve every paragraph that mentions context? 3. When a judge acknowledges service status and still manages the case forward because the respondent is actively invoking the court process, why are you acting like no service equals nothing else counts? 4. What document are you relying on to claim the service was unlawful? And why won't you put that exhibit on screen the way you demand precision from everyone else? This is your pattern across multiple clips. You take uncertainty, maybe no authorization, and you treat it like a proved fact, no authorization existed. Then you use that invented certainty to declare probable cause and retaliation fails. If you want to keep saying the record shows, then show it and explain the days later timing without pretending it's irrelevant.
Wow. In other words, he couldn't get further off base. And, yeah, that's a problem, man. It really is a problem. It's giving a lot of misinformation out.
Cheeky monkey. This is exactly where your probable cause, complaint-driven service defect house of cards starts leaning. Your whole narrative depends on pretending the citation was an immediate, on-scene, conduct-based response.
Oh, I
but the
already
sworn
played
record
that one.
says it wasn't.
So, here's the problem. Cheeky Monkey, for whatever reason, has decided to become a third party. We haven't even got through how many videos he's made just in the last 24 hours. They're all 5 minutes long, and we have like 10 more to go. I'm not going to bore you with it, because the person that is making the threats, person that has carried out those threats, is Robert. Slapping Tonic proves it. You'll have a good one. I'm going to leave this as is. You'll have a good one. May God be with you. May it be with someone.